So she should be coming down.
All right.
Ladies and gentlemen, we are ready to proceed. Defense, with the case.
Thank you. Good afternoon. If you're hearing me, please let me know. I heard the prosecutor say to you, theory. What I heard the prosecutor say to you is that in the moments leading up to the crash, with about 9 seconds to go, that George Pino was inattentive. He might have been looking over to his wife while she was trying to text a beautiful video of the girls who had a beautiful day over at the sandbar. He might have been looking at his GPS. He might have been looking over to his right or to his left, that he was inattentive. Those are her words. And if that is true, if that's the state's theory, George Pino, your job is very simple. George Pino is not guilty of a crime. He may have committed human error. He may well have been inattentive. He may not have looked up in time to see the marker to which the wallow alighted. But that does not make him a criminal. We have highlighted for you the law. After all, that's where we are. We're in a criminal courtroom of the United States of America, where if your government, my government, wants to brand somebody a criminal, they have to prove he's committed a crime. Not that he was negligent, not that he has civil liability. Footnote, all civil liability has been resolved already, long before you were sworn in as judge. This is not a civil case. This is not about whether, by a preponderance of the evidence, the state or I should say, the injured passengers have established liability, civil liability. That has already been resolved. We are here today because our government wants Mr. Pino to be branded a criminal for having, by their own statement to you, been inattentive. Now let's look at what the law is, because we are, after all, in a court of law. And what we've done is we've taken what we understand the judge's instructions of law to be before you on the screen. May not be so easy to read because of the distance. There are 2 crimes that are being charged: vessel homicide and manslaughter. Each of them requires that the state prove beyond a reasonable doubt certain facts. And there they are before you. That George Pino operated a vessel in a reckless manner, likely to cause death or great bodily harm to another person. His reckless operation caused or contributed to the death of Lucy. What does it mean to be reckless? Different than perhaps negligent. Reckless operation of a vessel requires the state to prove more than a failure to use ordinary care. And so even if you were to find that the operator of a motor vessel failed to use ordinary care by not looking up and seeing the marker in the few seconds before it alighted, that would be, even under the state's own theory, negligence, if that's what the state has proven. Because to prove it to be a crime, it has to be so willful or wanton. A willful or wanton disregard for the safety of persons or property. Intentional, knowing, and purposeful. Purposeful. A conscious and intentional indifference to consequences, with the knowledge that damage is likely to be done. It's not enough that a human being has failed to do everything he could or she could at a moment in time. This crime requires a purposeful act of indifference, a purposeful and reckless indifference to his passengers. If we look to the manslaughter charge, It specifically tells you it has to be an act that's not merely negligent. It's right there in the law. An intent to commit an act that was not merely negligent. We turn to the next page. Culpable negligence. So you've got recklessness as one principle of law that the state is trying to apply against George Pino. They've also tried to apply this principle of culpable negligence. Sounds like negligence, but it's negligence plus a whole lot more. It's more than a failure to use ordinary care towards others. It must be gross and flagrant. Think of those words in your daily life, gross and flagrant. Like in the NBA, just came to me. People commit fouls, NBA, National Basketball Association. There are fouls, and then there are flagrant fouls. You know a flagrant foul when you see it. Flagrant. It's not that when the basketball player is going to the hoop and his arm gets hit by another player, even if by accident. That may be a foul. But it's only flagrant when it gets to the point that it is so intentional, so diabolical. And even then, referees have to go back to the screen to see just how flagrant it was. If we're going to put a man, if we're going to label a man a criminal, it's got to be flagrant and gross, with an utter disregard for the safety of others. And that when George Pino, thank you, Ed, that when George Pino that morning woke up, when he decided he was going to host a group of friends of his daughter, that somewhere along the line that day, his brain somehow shifted into this gross and flagrant world. That he made conscious decisions, because that's what the law requires before we call him a criminal. And I'm sorry I'm getting a bit agitated. It's an emotional day, because we recognize that there was a lot of hurt that came of this event, a whole lot of hurt, a whole lot of pain. Pain that endures till today and will endure beyond today. So we have to acknowledge that, because we all feel it. And I'm sure you felt it as the prosecutor over and again played videos of the injuries and drama and chaos that ensued from the crash. Heartbreaking. Seeing a young girl that we now know wouldn't survive that event. Having to see CPR and medical examiner photos. But the law says that we don't judge these events based on sympathy, because we all have sympathy for those that were injured, those that passed away, those whose injuries will continue on beyond today. But we don't judge someone in a criminal courtroom under these statutes based upon the injuries and the fatality to turn what would ordinarily be just an accident into a criminal homicide. I heard the prosecutor try to give you an example, and I thought it was telling. She said, oh, if someone ran a stop sign and they had a fender bender, that would be just negligence. I think that's what she said. But if that same car, same driver, ran the stop sign, but instead of a fender bender, a mother with a stroller was walking in the crosswalk and got hit and severely injured or worse, would that change the character of the manner in which the person who was driving the car operated that vehicle? The level of injury, the death that might ensue under those circumstances does not then define the level of recklessness, the level of culpable negligence that we all are here to evaluate. And so with that framework, and with a further instruction that the burden of proof is on the state, if the government, your government, my government, intends to seek a criminal conviction, the government, the state, must prove its case. Not guess someone guilty, not speculate someone guilty, but prove that someone has committed a crime. And that's why the judge told you that we begin, each of us, as a citizen of this great country, citizen of the great state of Florida, we all start with a presumption of innocence. And that presumption carries with all of us whenever we are accused of something in a criminal courtroom until proven guilty. And the burden is proof beyond a reasonable doubt. It's the highest burden we impose upon our courts and our juries. You weigh all the evidence, but if there's not an abiding conviction of guilt, or if it's one which is not stable, but one which wavers and vacillates, then the charge is not proven beyond a reasonable doubt. And the law requires, as part of your oath, to return a not guilty verdict. That is the law. That's why we are here. And so, in evaluating the evidence, I'd like to first begin with just a few fact points that the prosecution has talked about. The prosecutor said to you she hasn't charged Mr. Pino with boating under the influence, so she doesn't understand why, I think she said, we have made such a big deal about Mr. Pino not being impaired. I ask you to recall the opening statement of the prosecutor when you first heard from her. And she said to you that Mr. Pino had 2 beers, and she did this little signal with her fingers as if it really wasn't 2 beers. And she said it to you again today, that maybe he had more. Maybe he had more. That is not evidence. A lawyer's assertion is not evidence. A prosecutor's assertion is not evidence. Just because she wants to argue it doesn't make it evidence. We had to bring out the evidence because the state was suggesting to you that it was more than 2 beers. That's why we are talking about it now, because the state is talking about it. And what was the evidence about beer consumption on that day by Mr. Pino? And we'll talk in a moment about the consumption of alcohol by the passengers and other people at the sandbar that day. Is there any evidence before you, even one witness, that has said to you that George Pino appeared impaired, buzzed, in some way compromised? Is there even one witness of all the people that were at the sandbar that day, of all the people that testified at this trial? Not a single person has said that George Pino was in any way impaired by alcohol. That should end it. We shouldn't have to talk about alcohol. But we have to because the prosecutor keeps insinuating that maybe there was more than 2 beers. Of course, the number of beers isn't the issue, since there's no evidence of it. It's the fact that Mr. Pino's consumption of 2 beers did not result in impairment. And you heard it from Lieutenant Thompson. He told Mr. Pino that it's perfectly acceptable over the course of the hours that Mr. Pino was there to have consumed 2 beers over several hours that afternoon. It's on tape. Lieutenant Thompson told that to Mr. Pino. Mr. Shapiro questioned Mr. Thompson, Lieutenant Thompson, who confirmed it's true. You do not break the law by consuming a couple of beers over the course of several hours and then operate a motor vessel. And you know that other adults that afternoon also consumed alcohol and operated a motor vessel, to include Lucy's dad And no one other than the prosecutor is suggesting anything about the consumption of alcohol having affected the ability of any of the adults that afternoon to operate their motor vessel. That should end it. But it doesn't with this prosecutor. She continues to insinuate that you should find what's not proven. And certainly you can't find that beyond a reasonable doubt. Later I'll go witness by witness to show you that this is not coming from me. I took notes of every witness's testimony on this and other subjects, and we'll talk about them. So that's the issue of impairment of alcohol. Let's talk about safety and speed. The prosecutor is emphasizing that Mr. Pino's motor vessel was traveling that day as fast as 47 miles per hour. Every single witness who testified that was on the boat, and I'm going to go through it one by one, felt the speed was safe. They'd been on his boat before. It felt no different. Nothing unusual about the way Mr. Pino was operating his vessel. He wasn't drag racing. He wasn't doing donuts in the water. He isn't like one of those jet skiers that's trying to jump weights and do all sorts of thrill-seeking activities. He was not, contrary to what the prosecutor said to you today, he was not trying to be the cool dad. I don't know where that came from. The cool dad. That Mr. Pino, according to the prosecutor, was in some great rush to get back to Ocean Reef because the party that he had planned for his daughter was going to start at 9 o'clock. It was then 6:37 when the accident happened, 2.5 hours to go until party time. As if to suggest Mr. Pino, in his mind, was worried that the girls wouldn't be ready on time and that he was then going to throw caution to the wind and drive the boat in a way that he had never driven before, because you've heard nothing. No evidence that Mr. Pino has ever had an issue with driving his motor vessel. And many of the passengers have been on Mr. Pino's boat before. That motor vessel, the Robalo, is built to handle that speed. Actually, it's built to handle more speed. You may recall that boat had two 300 horsepower engines. That boat is rated to have two 350 horsepower engines. That boat is built to handle an additional 100 horsepower of speed. He equipped it with motors that would provide less speed than the motorboat is equipped to handle. The passengers were seated exactly where the manufacturer of that boat designates passengers to sit. Every passenger's butt was on a cushion. None of the passengers were standing. None of the passengers were sitting on the gunnel. You by now know what the gunnel is. That's the surface at the front. And to suggest that Mr. Pino, could we put the reckless homicide vessel? To suggest that he was being flagrant. Next thing, is better for me. No, sorry. There you go. Perfect. That he was being gross and flagrant and disregarding their safety by having the passengers sit exactly where a company that's been in business for decades. I think this Lieutenant Albert said they've been bought out by some huge conglomerate. You didn't hear 1 ounce of evidence that Robalo had notified the operators that there should be no passengers seated in the designated seating. You did not see a label on the boat saying, "Do not sit here." I mean, we live in a society where every package has a warning on it. You buy a pack of cigarettes, it says, "Warning, if you continue to smoke these, it may cause cancer." You go to McDonald's and it has to caution you that they have hot coffee in a hot coffee cup. We give warnings to people for any possible liability. You come home from the dry cleaners with your shirt on a hanger, you take the plastic bag off, and if you read the bag, it says, "Careful, don't put it over your head. You could suffocate if you wrap a plastic bag around your head. We are a society that is so litigious that we warn everybody of any possible misuse of a product. And yet, you did not hear 1 ounce of evidence, not a witness, not even Lieutenant Albert tell you that Robalo has suggested to any of its operators over the last 40 or 50 years that the boat is not equipped to have passengers seated in the designated passenger seats. And yet the prosecutor is suggesting to you he's driving the boat in a reckless manner or in a gross and flagrant manner by having passengers sit where they are designated to sit. I mean, that's just not fair. That's not fair to the operator of the motor vessel. It's just not fair. Let's talk about the speed. How many witnesses testified that the speed at which those witnesses were traveling, some of them law enforcement officers, others just ordinary boaters like David Rodriguez, whose boat can achieve 80 miles per hour, that he was doing 50 to 55 miles an hour that day? There was nothing about the speed at which the Robalo was traveling that was at all excessive, gross, or flagrant. And let's say what we all know to be the absolute truth here. If George had not hit the piling, nothing bad would have happened. The conditions were ideal. The waters were calm. It was not a windy day. It was not raining. It was no lightning. There was no oncoming boat traffic. It was wide open bay. The speed had nothing to do with the injuries. What caused the injuries was the crash. Of course, the faster you go, the more likely someone's going to get hurt. Of course, if he bumps it at 1 mile an hour, nobody gets hurt. But the speed in and of itself did not create the danger. Hitting the marker was the problem. So we all understand that, I hope. No one on the boat asked George Pino to slow down. No one said, hey, I'm scared, we're going too fast. Not Mr. Pino's wife, not his daughter, and not any of the other passengers. And with the speed at which Mr. Pino was traveling, even at 47 miles per hour, the state's theory is that with 9 seconds to go, Mr. Pino was on a course that would take it into the marker. And as you may recall, when I examined some of the witnesses, with 9 seconds to go, there's plenty of time to simply turn the wheel slightly and avoid the marker, if George Pino had seen it as he was approaching the marker. Of course, if the state's theory was, he was, for those 6 or 7 seconds, inattentive, that would explain why he hit the marker. He had plenty of time to do it, that is, to change course. But because of inattentiveness, according to the prosecutors, he didn't change course in time. Not reckless, conscious, flagrant disregard. This Robalo boat is yacht certified. That means that it's built to take that many passengers. There is no weight limitation. This idea that 1,000 pounds of passengers is going to create a dangerous situation. No one has said that Robalo warned George Pino or any of its other operators of the state's theory that they're advancing to you in this courtroom. So we've dealt for the moment with the alcohol used by Mr. Pino. I'm talking to you now about the speed at which he was traveling and the way he was driving. And so I want to ask you to imagine on that day, if there was a drone watching Mr. Pino's operation of the vessel, both from Ocean Reef to Billy's Point, to the sandbar, and back. If any of us was watching, would someone have said, that boat traveling, that way it's traveling, that guy's driving like a lunatic? Because that's what this crime is basically suggesting. Because you know a reckless driver when you see it. It's the lunatic on I-95, cutting through cars, going 30, 40 miles over the speed limit. You know the reckless driver when you see that person. George Pino his boat was traveling on straight lines at speeds that Ravallo is designed to travel at, in a zone where there is no speed limit. No posted speed limit, not then, in 2020, 2022, and not today. If it was so inherently dangerous to travel at speeds in the 40s, you have to ask why there is no speed limit posted there. You heard Lieutenant Albert when I questioned him. There are speed limits all through Biscayne Bay. On Miami Beach, on the Lloyd Channel, I spoke to him about that. Posted speed limits like you see on the street. And yet, this channel, Cutter Bay, had no speed limit in 2022 and none today. It's not fair, it's not right to tell George Pino after the fact that there should be a speed limit there. I'd like to talk to you now about the government's emphasis about George's imperfect, inaccurate, unreliable memory of the crash. After the crash, and we'll talk more about George's efforts to help people after he regained consciousness, but for now, it's undisputed that as a result of the crash, the collision, George Pino lost consciousness. He was laying on the floor of the boat, unconscious. Witnesses thought he was dead, bleeding from his head. 4 of his front teeth. Maybe you'll help me find it. What do you have there? Thanks. The prosecutor said no big deal because the impact only shaved off part of his teeth. That we might have a better argument, I think the prosecutor was suggesting, if he'd lost the teeth completely. So George Pino, by all accounts, unconscious on the floor of the boat. He'd hit his face on the floor of the boat and then the back of his head hit the boat. He had 2 places of impact. He was knocked unconscious. We asked a doctor to come testify because the state did not produce a medical witness on the issue of George's injury. We brought you the only medical testimony about that, Dr. Barrett. And before we get into the substance of her testimony, let's talk about the cross-examination of Dr. Barrett to attack her because she charges for her time. This is someone who's been a professor at medical school. She's been a doctor for decades. Her credentials are unimpeachable. And yet the prosecutor is focusing on how much money she charges for her time, that she charges for all her patients. The prosecutor was making something of her preference not to have to process insurance for her patients. They're able to seek reimbursement from the insurance company, but she doesn't do that. She accepts direct payment, and then if they want to be reimbursed from their insurance company, that's okay. As if to suggest you shouldn't consider her testimony because she doesn't accept insurance and because she doesn't work for free. Now, I never asked Lieutenant Albert how much he was charging the state for his time. He's also a paid witness. Because I wasn't going to go there as if to suggest to you that a man who for decades has been a law enforcement officer, would lie to you for money. And I think that's what the prosecutor is suggesting that Dr. Barrett did. That's frightening. Because that's what she's suggesting to you. That because she doesn't accept insurance, and because she charges for her time, after all, someone had to pay so she could go to undergrad and medical school and residency. Those of you who have family members that have become doctors and specialists, it takes a decade to get to the point where you can be someone of her level. And rather than bring you a rebuttal witness, they brought you no one. They attacked the doctor for telling you what is black and white law of medicine, the principles of medicine. Medicine, she explained to all of us, makes a diagnosis of a traumatic brain injury focus on what happened at the time of impact and in the 72 hours after, not 3 years later. And Dr. Barrett explained to you that because George was seen unconscious by multiple witnesses, and because it was obvious that he had amnesia because he was recalling inaccurately so many of the details of the crash, the diagnosis was beyond dispute. The man was unconscious. He suffered a traumatic brain injury. Now, the word traumatic, I think, is a word that is giving the prosecutor some concern because it sounds traumatic. It should be like he needed to go to a hospital and stay there for a month. But that's not how concussions work. And the doctor explained it to you. And so the questions of a lawyer who worked for the state, not for free, by the way, who is attacking a doctor, a professor, the questions of the lawyer are not evidence. The suppositions of a lawyer are not evidence. The evidence comes from the witness stand. And the only evidence that was presented to you about the issue of George's memory came from an accomplished doctor, one who's a professor, one who has published, albeit she doesn't accept insurance. And she explained to you that George Pino, having suffered a concussion, diagnosed with a traumatic brain injury, unable to accurately recall events related to the crash, including, for example, which boat he was on. He thought he was on the boat that had the 225 horsepower engines that he had previously. He thought he had hit the left side of the boat, he thought the left side of his boat had hit the marker when it was the right side. He recalled to Lieutenant Thompson that it was Nati he had pulled out from under the boat when we know it was someone else, it was Lucy. All of those mistakes made it clear that George Pino was suffering from a TBI, a concussion, and that his memory would not be reliable. It doesn't mean he had total amnesia. The prosecutor was suggesting to you that he should remember nothing to convince you that he's had amnesia and what they call in the medical world confabulation, filling in details about the event from past memories or other memories. And so when George Pino was recounting what he remembered from the crash, and he thought he remembered that there was a wave that came from another boat, that was his memory of it. It may not be reliable, but there are two things that hold true. First, the science establishes that those are the kinds of failed memories and inaccurate memories and false memories that happen after a concussion. And second, it doesn't tell us, and we don't rely upon it, and you don't have to rely upon it in deciding what actually did cause the accident. Was there another boat with a wave? You can disregard it altogether. And you may recall Mr. Shapiro, when he was questioning Lieutenant Thompson, confirmed that no one else saw a boat out there that day coming back from that marker area immediately after the crash. And so We assume there was no other boat for purposes of deciding and for you to decide whether George Pino acted recklessly or conscious disregard for safety. And because there was no other boat, and because the conditions were ideal, the state really has no theory of why George should be labeled a criminal. Because it's not like George was going and racing through incoming traffic, going zigzagging out of boats, and then hit the marker. It was a perfectly, as everyone said, it was like the ideal day to go boating. And it comes back to what I told you earlier when we started. That what the state is telling you is that George made a mistake. He didn't see the marker. And now we're going to talk about what's left of the case, in a criminal case, where the state has no theory other than to bring to your attention things that they try to influence your decision based on facts that have nothing to do with the operation of the motor vessel. Let's start with underage drinking. And it was a subject of our jury selection when we talked about this early on. Whether the girls, the passengers, were 17 or 27, the age makes no difference. We're not here to judge these parents based on their decision to allow 17-year-old high school seniors to drink. None of them were operating the boat. All of them were seated where they're supposed to sit. There was a life preserver for each and every one available. True, none of them was wearing one, but the law doesn't require it. George complied with the law by having a life preserver available for every single passenger on that boat. Nothing more was required. And what the state is saying is to you is that every time someone comes on your boat and has drinks, and I don't know if it's limited by age, but now the operator of the motor vessel needs to put a life preserver on every drinking passenger. Now I assume that doesn't apply on big cruise ships, which are famous for people going drinking, or big yachts, maybe. I don't know where the line is going to be drawn in the future. But beware if you're a boater. Beware. Because you take a group of people out on your boat, and they have a few drinks. Some prosecutor will say that because you didn't put a life preserver on that passenger, you are now a reckless boating operator. Because that's what she's saying. But she focuses on the age again, I think, to just sort of to do two things. It's really, of course, much more painful to know that a young person passed. And let me point out that I think the medical examiner told us that there was no evidence that Lucy had any blood alcohol in her system when they tested her. So I don't think there was any evidence that Lucy was drinking. I don't think there was any evidence about that at all. Some of the other girls were for sure. Nothing about Lucy drinking. But it sounds to me like what the prosecutor wants you to do is say he's a bad parent because he, and by the way, the other parents at the sandbar, to include Lucy's parents, are bad parents. And so let's convict them of being irresponsible parents and call them reckless and callous. The underage or any age drinking of the passengers had nothing to do with why the boat hit the marker. I hope that's clear by now. Nor did the absence of a kill switch. Those of you that may not have been on a boat before, we try to explain it. It's like string that you attach to a button on the console so that if the pilot, the operator, is dislodged or falls into the water, it automatically stops the engines. And the prosecutor wanted you to know that there's no evidence that George had a kill switch. Not required by law. Would not have changed the outcome here. But the prosecutor wanted you to know that, and that the flares that were on the boat were expired. Even though I brought out through Lieutenant Alder, even expired flares can serve the function, although it doesn't comply literally with the regulations. And of course, flares had nothing to do with this case, and having unexpired flares wouldn't have changed the outcome here. All right. now I'd like to spend some time talking about the witnesses. That's the evidence, the people you heard from, so that you have no doubt that when I share something with you, I am doing my very best to rely on the evidence and not on my theory or my argument. I want to rely, and I want you to please rely, as is your oath, on the evidence. And I sequence them differently than in the order that you heard them, to try to do it in a more organized fashion. I'm not particularly famous for being organized, but I've tried my best so that we can cover the subject together in a meaningful way. Everything starts at Ocean Reef. That's the place where the Pinos were celebrating their daughter's 18th birthday. And in addition to the virtual mass and the pickleball tournament that George organized and the boat ride that he had organized, there was going to be an event that night at 9 o'clock, dinner, the end of the night. After, I guess, the Florida State game, it was the Florida State game that was being played that evening. And George Pino organized the dinner to start at 9, and it was going to go until 11. But you heard from a witness named Araceli Alvarez, she was the event planner at Ocean Reef, that they could show up late and stay late because there was no other event afterward. And I thought that that's important because the prosecutor's theory is that George became reckless, he became indifferent to people's safety because he wanted to make sure the girls were Instagram ready in time for this party. That's their theory. He was worried about them being Instagram ready. And that he'd be willing to risk the lives of these girls so that they could shower on time. Then we have the testimony of the people that attended the sandbar and the events of the day. It included Lucy's dad, Andres. And here's what he testified to as part of the state's presentation, including the answers to the questions that were asked on cross-examination. He was not concerned that George Pino had consumed too much alcohol. He himself had consumed alcohol. He felt he was able to operate his motor vessel. He did operate his motor vessel. He drove his motor vessel the exact same place that George Pino would drive his motor vessel. He allowed his daughter to drink. It was part of the so-called culture. He knew Ceci Pino almost his entire life. There was a loving relationship between these families. He was at the sandbar until at least 5:41 p.m., and we know it's 5:41 p.m. because there's a photograph of the Fernandez. I think it's going to say, I don't remember the mark of the boat, but it's a 20-footer more or less. And you recall Mr. Fernandez is floating in the boat, in the water behind the boat, and that was timestamped 5:41 p.m. And you know that George Pino left at 6:18 p.m. from the sandbar. So up until 5:41 p.m., at least, sometime after the Fernandez boat leaves the area, Mr. Fernandez had not remembered until we examined him the other day that actually he was planning to attend the sandbar, had changed his mind. We know that because we produced the text message where he told George, for sure I'll be at the sandbar. But then he changed his mind. That's fine. And he did come out. And you heard nothing to suggest that any of the adults at the sandbar thought that there were too many passengers on George Pino's boat. This is really important in my view, because the state's theory is too many people sitting on that boat to be safe. The same passengers that landed at the sandbar from Ocean Reef, the 14 people on board, were the same 14 people that went back. So if it was not reckless and not flagrant and not consciously indifferent to have 14 people in that boat coming to the sandbar, The same should hold true going back to Ocean Reef. And if any of the adults or the parents at the sandbar thought there was something unsafe about these underage girls who've been drinking going back on Pino's boat where they came from, they could say so. Not 1 ounce of evidence that George Pino was told by any of the adults there that day that, hey, George, too many people on your boat, or anything of the sort. Four passengers testified. Tammy Alvarez, Carolina Monterrey, Claudia Portocarrero, and Natalia Reed. Tammy Alvarez testified that after the collision, she thought Pino was dead. On the way to Billy's Point, she felt safe and comfortable. There was no unsafe driving by Mr. Pino. She had no reason to believe he was impaired. No sense of danger, excessive speed, or risk on the return trip before the crash. Here's the quote I wrote down. When Mr. Pino was driving his boat back from Billy's Point, did you feel that he was driving in a dangerous way? Answer, no. She did not notice any perceptible change in speed, and she remembered that George made sure that everybody was seated, what you would expect a prudent operator to do. The prosecutor will use that against George by saying, George, because you told everybody to sit down, you knew you were going to do something dangerous. So imagine that argument from our government. By doing something prudent, by having everyone sit down as is proper, it's, in the state's view, she testified that for a split second, she saw Pino lying between the console with his eyes closed, blood on his head, and thought he was dead. She also said that she and Natalia Reed, Nati, had never been confused for any of the other girls like Lucy. And that was important because George inaccurately thought initially that he had pulled Nati from under the boat. So those four passengers testified. Of course, the state will emphasize that some of the girls themselves were intoxicated. And can we put on the screen exhibit T like tango? Thank you. If the state had another witness to contradict the four passengers on the boat, they could call any one of the witnesses on the list that was provided as exhibit T. We had Mrs. Pino do a count of individuals in the sandbar. By her count, 13 girls, 8 boys, 15 adults, for 36 total. Just look at the full page. The state did not call any witness from the sandbar to contradict the evidence that I've just discussed with you. Now, Cecilia Pino, the mom, no one is suggesting that she is suicidal or homicidal. She was concerned about her own safety and that of her daughter, little Ceci, and the girls who she's known since most of them were born. There's no suggestion that she would get on a boat with someone who was intoxicated, driving at lunatic speeds, and subject herself, her daughter, and these girls who she loved to danger. Because if you find that George was doing this, you're basically saying so too was Ceci Pino. That the mother of little Ceci, the camp mom, for lack of a better word, that she too was, quote, reckless in allowing her husband to operate the vessel. It's the only inference you can draw. What else would you say? And not at one moment in time did Cecilia Pino, the mom, say, hey, George, slow down. She didn't feel there was any danger. None of the passengers said, hey, George, slow down. That's the unrebutted testimony. If you need a break, I can take a break. 36 people at the sandbar, 15 of them adults, sharing an afternoon and sharing alcohol. The state put before you the picture of all the empties, the empty bottles. So the Pinos serve as basically the garbage can for that afternoon. That boat becomes one huge garbage can. And everybody puts all the garbage on their boat. And no good deed goes unpunished, because now the state parades before you all of the bottles. And so, being responsible citizens is now evidence against them. Mrs. Pino she told you, I brought it up right at the beginning. She felt totally comfortable motoring along. Can we put up A28? Oh, sorry, V Victor. This is a picture time-stamped at about 6:31 p.m. Just full screen first. There you go, that's good. So, hoping everyone can see, this is a picture from the stern, that's a word we use in boating, the rear of the boat. That's George Pino with the hat, white hat, and Ceci, his wife, sitting next to him. You can actually see the sun catching the right side of his face, and he's staring into the sunset, so to speak, although it's about an hour and a half before sunset. And of course, the state is critical of questions that are asked by the defense about the sun and the tides and all of the circumstances. But of course, the reason why all of these questions are asked is to get the evidence out to you so you can evaluate the facts. And so, for example, if it was 8 in the morning, the sun would be to the east on his left. And so it might be very important in understanding how the sun creates glare off of the water surface in deciding what visibility someone might have late in the afternoon. The state brought you no evidence, no discussion, no analysis of that. Okay. But what you have is George Pino on this boat, and all of you had an opportunity to see the boat in person. George Pino is not 6 foot 8 inches tall like Paul Alvarez, whose head would be a foot above George Pino. And you can get a sense, because some of you stood on the boat, and you can see that the boat, when it's on plane, and I'm doing a profile, the boat's bow comes up. On plane means the boat has already accelerated, got over the hump, so to speak, and is now riding on a plane. That's what they call it. And so, this is the windshield. So the 47 mile per hour that the prosecutor was talking about, the wind, there's a windshield. For that reason exactly. It's not like a motorcycle, which has, some of them have no windshield. This one has a windshield. And on this boat, if we can put up C. Charlie. There's the bow seating that we talked about. This one doesn't have cushions on it right now, because this is after the fact. But this is where the passengers were seated. And you already heard the testimony that their torsos and their heads would protrude above this gunnel, the freeboard of the boat. And those of you that saw it probably took note that that boat, when it's floating in the water, that bow of the boat, you can decide for yourself. You all saw it. You can decide for yourself. How high is it above the water line when it's floating? And the operator, who's a foot shorter than Lieutenant Albert, what is he looking at as he looks to the front? Certainly he's going to see the passengers that are sitting there, who are facing him. We'll talk about that more in a moment. Ceci Pino, in the picture I just asked Mr. Armolino to show you, she's actually in the process of sending a text using her phone. Now, let's understand the rules of the road, because the navigation rules have been presented to you. There's no requirement that a boat operator have a separate person serve as a lookout. You're about the lookout rule. I can drive my boat all by myself, provided that I'm looking where I'm going and I'm serving as a lookout for my boat. Just want to be sure there's no confusion here. I asked the witness, very clear, the operator can be the lookout. You can have more than one lookout if you like, for sure. And then, you'll hear in a moment, or you'll see it when we talk about it, the operator's head is on a swivel. Because when one's operating a boat on the open bay, there are no traffic signals, there are no yellow lines and white lines, there are these markers from time to time, but for the most part it's just open bay and potentially boat traffic. And so, no different than driving a car, you need to look where you're going. I remember that from when I was a kid. My dad would say, hey, son, look where you're going. And if you don't look where you're going because you're inattentive, you might fall. If you don't look where you're going because you're distracted, you might trip. Or, as might be the case according to the state, if you don't look where you're going at some point in time, you might hit something. That's what we call a crash, an accident. And if that's what happened here, it's not a crime. The judge will instruct you about those navigation rules. I'm good. Thank you. In the state of Florida, the law requires operators of vessels upon its waters to follow the navigation rules. However, a violation of these rules, individually or cumulatively, is not sufficient by itself to constitute culpable negligence or recklessness. Even if an operator violates one rule, or even multiple rules, individually or cumulatively, that is not enough in and of itself to establish recklessness or negligence. It's back to whether you're driving a car or driving a boat. If you fail to see the stop sign, it could even be a stop sign that you've passed 100 times. You're not paying attention that day. You're going to work and you're thinking about something else. You fail to stop at the stop sign and something awful happens. And that's what we call an accident. Thank you. And like when you're driving to work every day, when you get into a routine, just draw on your own life experience. Each of you has life experience to bring to the courthouse. You've driven this path 100 times. Sometimes you leave your house, you get to work, and you don't remember passing half the places that you know are on the way. You just never noticed them. You were just daydreaming. Who knows what you're thinking about? Or, my wife will forgive me for saying this, she runs over that same pothole every time. That she should know by now there's a pothole down the street, don't run over the pothole. It doesn't make people criminals for being human and overlooking those things. Particularly when your brain is on autopilot. Not real autopilot like a boat, but you're just coming along doing your routine. And if all the state proves to you is that George Pino was on his way back to Ocean Reef, as he always was, and he overlooked marker 15 and he hit it, he'll be held accountable in civil court as he was, but that doesn't make him a criminal. Mrs. Pino, to finish her testimony, corroborated what every other witness testified. Her husband suffered a head injury, fractured teeth, stitched elbow, a leg gash. It's beyond dispute. But what the state does to try to, again, avoid dealing with the lack of a theory of criminality, instead is focusing on that the Pinos, several months after the accident, with George suffering from the post-traumatic stress, you heard he's on psychiatric medications, they go on a family trip to the Panhandle, and for maybe the first time in 4 months, he breaks out a smile with his daughters. And I think what they're saying to you is that should convince you that George's lacked sympathy because he was smiling and one of his daughters posted the picture. That you should find him guilty because he had the nerve to smile for a photograph with his daughters. The first smile he might have mustered in many months and maybe very few since. And perhaps in the most awkward moment of the trial, knowing that Mrs. Pino had spent much of her motherhood with her daughter and her daughter's friends, including Lucy, she's confronted with a photograph of Lucy by the prosecutor, saying, "That's not your daughter, is it?" Why would somebody do that? Why would that question be asked? Mrs. Pino explained to you she didn't see the accident, and that's why when she was in that civil case having to explain what she knew, she had to rely on her husband's memory, which we know from the science may not be reliable, but that's all she knew about the cause of the accident. You heard from several good Samaritans. Hillary Candela, Hamlet Rodriguez, and David Rodriguez. These were boaters who came upon the scene Hillary Candela, a gentleman, he did know George Pino by coincidence. He remembers seeing George looking dazed and in shock. That when Hillary Candela screamed out to George, "Look under the boat," the first time George didn't seem to register the instruction. Second time he did, and George Pino went under the boat and brought Lucy back from underneath. Hamlet Rodriguez was the person to whom George Pino handed off Lucy so she could get to a boat. Hamlet Rodriguez, a former water polo player, did everything he could to help her. He said he was swallowing water against a strong current until someone pulled him out. He left the scene around 7:05, Hamlet Rodriguez, which happens to coincide when David Rodriguez, unrelated to Hamlet, who had been cruising at 50 to 55 miles per hour, sped up to 70 miles per hour to get to the scene. Yes, of course, he sped up because it was an emergency situation, but he said it felt perfectly safe to travel at those speeds. He saw a mature woman bleeding who said a girl was missing. Likely Ceci Pino, since that was the only adult passenger on the boat that he saw bleeding. And I think she told me she was hospitalized after that night. Mr. Pino, by then, was apparently hanging on to the capsized boat after he had passed Lucy off to Hamlet Rodriguez. David Rodriguez described Pino very in shock, crying, but did comprehend instructions. Pino kept asking David, "Are all the girls okay?" Pino would not get out of the water until he was assured that every girl was out of the water. That was 7:04 p.m., I believe, was the timestamp on that. He was asked to look at his camera. What time did you photograph George Pino still in the water? 7:04. The accident occurred, according to the GPS, at 6:37 p.m. 25 minutes, if my math is not wrong, that George Pino stayed with that boat until everybody was out of the water. And to get out of the water, George Pino had to negotiate a swim platform with a tie bar that David Rodriguez explained was no easy task. And David Rodriguez took the unusual step to put his face in George Pino's face. To see if George Pino smelled like alcohol, had bloodshot eyes, slurred his speech. And David Rodriguez, who was curious, maybe even suspicious, I think he said, was satisfied that George Pino was not under the influence of alcohol, that alcohol was not impairing George Pino. And we're talking now 20 minutes after the incident. Maybe 25 to be more precise. Then the first responders came to the scene. You heard about Officer Bruto, now retired. He was the first officer on the scene. He saw George Pino get out under his own power. No stumbling. Even Bruto was concerned about a concussion. He said safety first. George had a head injury. But still, George Pino was able to keep his balance on a narrow 6-inch gunwale. No signs of impairment, said Bruto. Speech not slurred, no balance problems. I mean, you talk about taking a sobriety test. That is probably the most difficult sobriety test anyone could take. Bruno himself traveled at near top speed at 52 to 54 miles per hour in emergency mode. Quote, here was the question: the conditions allowed you to travel safely at nearly 54 or 52 to 54 miles per hour. In other words, the top speed that your vessel is capable of. Correct? Answer, correct. So you have an opinion from a law enforcement officer that the speed is safe to travel. First responder Peter Delgado, a sergeant with the Miami-Dade Sheriff's Office. He triaged Mr. Pino, meaning he rendered first aid. He confirmed, of course, that no life-saving devices, personal flotation devices are required to be worn. The Pino vessel had the required PFDs, none are required to be worn. He's the officer who began talking to us about those markers, the staggered markers in Cutter Bank, and how staggering the markers, as I think you'll see in a few minutes, is less simple, let's say it that way, when the markers are staggered versus red, green, or depending on the side you're looking from. He could see that Pino was an injured passenger, bleeding from his head, and he told Pino do not go to sleep because he was concerned that Pino had a concussion, and going to sleep could be dangerous for someone with a concussion. He too observed no signs of impairment. And no other officer on the scene reported to Delgado or to any other person who's testified in the trial any signs of impairment. John Dalton with the Miami-Dade Sheriff's Office, he transported the girls from the accident scene to Elliott Key. He testified, and this is the best quote I have about speed, quote, no more than 40, 45, maybe at max, because they were panic-stricken and begged him not to drive fast, and it was getting dark. As an officer, saying 40 to 45 is not fast. The opposite of not fast, maybe not slow, but it's certainly, it's safe. Let's call it that. That's what the officer called it. The girls on Dalton's boat were sitting, I believe they were sitting, yes, seated on the floor and console at the bow, at the front of the boat. By then it was nighttime, doing in the 40s at night. Question, and you felt in those conditions that was a safe speed for you to travel? Answer, yes, sir. He's the one who talked about keeping your head on a swivel, that the operator of the boat has to keep his head on a swivel. And what that means is, as someone's operating a boat, since there's no traffic lights, no stop signs, no yield signs, no turn signals, which means that if a boat is coming behind you faster, right, that boat could come up behind you, and so while you're operating a boat, you've got to take a look from time to time. You've got to swivel, look at your instruments, look at your passengers, and if it takes you more than 6 or 7 seconds to do all of that in one swivel, you might just hit the marker. Lieutenant Thompson testified. He's the witness to whom George Pino candidly said, hey, I had 2 beers. And it was Thompson who explained to them that's okay. It's not illegal to drink and operate a boat. Those were the words of Thompson. Quote, it's not illegal to drink a beer or a couple of beers and drive. And that's a true statement, isn't it? Answer, yes, sir. Now, Lieutenant Thompson was the responder who took the recorded statement from Mr. Pino that you all have seen. Of course, you can judge for yourself in terms of Mr. Pino's speech whether he appeared to be impaired. A concussed brain, and let's be sure we distinguish between concussion and intoxicated. A concussed brain can fail to record memories. So you can have a concussion, according to Dr. Barrett, your brain is not recording memories, but then when you finally come out of the concussion, you can achieve this score of 15 in the Glasgow scale. So you've got your wits about you, but your memory's not restored. But when George Pino was recounting what his memory was to Lieutenant Thompson, which is recorded, George Pino did not accurately recall the details of the crash. I went through those with you already. And you'll see, if you decide to look at the video, that the first responders had to wrap George's head in a gauze. And I heard the prosecutor said only 7 staples. Is there a number of staples after which you're convinced that someone's had a concussion? 7 staples on a man's head with the teeth getting bashed in, loose chipping teeth? That's not enough, according to our prosecutor. And so Lieutenant Thompson, together with the help of some other CSI, crime scene type people, did a recreation. But the boat used for the recreation was Thompson's boat, which doesn't have bow seating, which doesn't have the higher gun. And according to Lieutenant Albert, only tracked the last 9 seconds of Mr. Pino's voyage. That was what they were trying to replicate, of course, with the exception of hitting the marker. And that within the last second or so, there's that buoy, and then Lieutenant Thompson avoids hitting the marker. What it proves to you is that if someone is attentive, someone's paying attention, even at that speed, with that lighting, in those conditions, the marker can be avoided. If the operator is inattentive for some reason, is looking at his instrument, swiveling his head, in the time I've just said that, 8 seconds have gone by, he'll hit the marker. Now, we had a little back and forth. It's not going to be a huge point, but I thought it was important again to bring the facts to you. It was high tide when this accident happened. High tide. Thompson thought high tide was at 4:44 in the afternoon. He was wrong by 2 hours. Lieutenant Albert thought, according to his report, it was at 10:30 at night. So the two of them were completely at odds with each other in terms of what they thought high tide was. And I asked, and Lieutenant Albert complied. Let's get the right answer for this jury. Let's go look at the right answer. Let's not have the wrong answer, even if it only means a foot or a foot and a half of difference in terms of the tide. One witness says the tide shifted 3 feet. They presented evidence. Mr. Albert said it was about 1.75 feet above the normal mean of the water. All evidence is clear. It was high tide when this crash occurred. Ed, can we put on the screen D delta? And you may recall I used the tape measure to establish that at high tide, 6 feet plus 3 feet is 9 feet at the top of the marker. I believe this is what the state says is the size of the marker. And if on the piling, this is the marker. Green, of course. Okay? And so you have your experience of having gone to see the boat, where the gunnel of that boat would be relative to the pilot that I represent right now. And whether someone sitting on that gunnel might obscure the operator's view. Of course, should the operator, under normal circumstances, if he recognizes that his view is obscured, request that the passengers make room? Of course. But that's not reckless and conscious and flagrant and gross to overlook that problem. Now, marker 13A, not 13, the prosecutor said 13, let's be clear, there's a 13 and a 13A. Let's put 13A. So testimony is that 13A is 5 feet taller. Lieutenant Albert said it was 5 feet taller. So I brought a tape measure. Three and a half inches. So 13A, the bottom of 13A, the bottom, would be 5 feet above my head. Okay? The top would be 3 feet tall. Okay? So 13A, that would be 8. 5 plus 3, 8 feet. That's the top of 13A. Okay? And you can see that quite clearly in Exhibit I, which is a photograph that we showed you through Lieutenant Albert. Hold that right there. Southbound, going back to Ocean Reef. There's 13A. Here's 13. So it's 12, 13, 13A, 14. They're staggered over there. And if we can zoom in, you can see at this angle, there's 15 obscured behind 13A. And I asked Lieutenant Albert, and again, I didn't ask him how much he gets paid. I trusted that he'd be honest. Wouldn't matter how much he's getting paid. He's a law enforcement officer. I believe he would do the job, and he did. Please tell the jury if there was a point in time where those two markers, if the operator was looking through the channel where the GPS track showed, was there a point in time where marker 13A would obscure marker 15? And he said yes. And I think we have that in the Lieutenant Albert F. Next one. No, you wouldn't go too far down. Up. There you go. G, I, up here, right there. Is that it? I'll find it in a second. We'll find it in a second for you. But the testimony was that at 34 seconds to go, that's the number that he testified, Lieutenant Albert. 34 seconds to go, those pilings line up with the operator's view. Now let me be clear. George Pino has no memory of this, no reliable memory of the crash. And I'm not saying to you that in fact, that at that precise moment in time, with 34 seconds to go, George Pino looked up, was looking down the channel, and they were obscured. Although the prosecutor brought out from Albert that at 34 seconds to go, it might be that green marker 15 is not even visible because it's still too far away for the human eye to see it. Don't have a reliable memory of what happened, but nor does the state. Nor does the state. But one thing we know for certain, the tape measure doesn't lie. The GPS doesn't lie, the tape measure doesn't lie. And we know for certain that marker 15, for reasons that the Coast Guard will have to explain at some other time, why would they make a marker 5 feet lower than all the other ones in the channel? We're not blaming the Coast Guard, because I'm waiting for the prosecutor to stand up and say the defense is blaming the Coast Guard. I'm just bringing you the facts. And that's a fact. And so when we saw the recreation of Lieutenant Thompson mimicking what the Robalo might have done, it did not give you a visual of what the operator of the boat, of the Robalo, was seeing in the last 9 seconds. Because the camera that Lieutenant Thompson was using was in front of the windshield, not at the position where the operator stands. This exercise of crime scene investigation, you heard from Manuel Palmares. He confirmed that marker 15 is the shortest marker in the cutter band channel. He talked about the green paint, that the green transfer onto the Robalo. Yep, that's it. Right there. No problem. Just to finish out the loop. The accident happens at 6:37:19. Someone will tell me if I got that. Excuse me, 6:37:28. 6:37:28. At 6:36:54, so let's do our math together. That's 6 seconds before 7 p.m. I'm sorry, 6 seconds before 6:37, plus another 28 seconds. 28 plus 6 is 34. 34 seconds from this point until elision. 34 seconds. And that's where 13A obscures 15. If the boat is here, the operator is looking down the channel, the operator's view would be obscured. And I'm going to repeat myself one more time. Don't know if that's what happened. But it's not our burden to prove to you what happened. Our burden is nothing. Our burden is to appear here in court and answer, we're here. But we don't have to present any evidence. But we take the step to bring you all of the evidence for you to consider. If the operator is looking down the channel, could the operator have counted 2 green on the left, 2 red on the right, continues for 10, 15, 20 seconds, and when the operator passes marker 13A, having counted 2 green on the left, 2 red on the right, thought, I just passed the last marker, the last green marker in Cutter Bank Channel, veers towards the left to go to Angelfish Creek, and says, hi honey, what are you doing? I'm sending a text message. 8 seconds later, there's a collision. Don't know, but the state has to explain to you why what happened there was more than just, as they've said so far, mere inattention. That was Palmares. Bengal Dahl, Detective Miami-Dade Sheriff's Office. He was the one, I think he was photographing, he was the drone guy. He said that the operation by Lieutenant Thompson in recreating what the Robalo did was, quote, safe so long as you don't hit the channel marker. Well, we all agree. What George Pino was doing was safe, provided he sees the marker in time to avoid it. And let me make one other thing clear. Green marker 15 is visible. To use the word as we understand it, it's visible. It's 3 by 3. If you're looking straight at it, you're going to see it. If it's like the pothole down the street, it doesn't, you can see it, but it's just not registering, you could miss it, even though you could see it. When I say miss it, I mean you could not recognize or not register that it's there. And if you do that, it means you're human. It happens to us as humans. It doesn't turn us into criminals. And Bengal Dahl, he testified that the exercise of having Lieutenant Thompson copy the path that the Robalo took, showed a steady course. No weaving, no hot dogging, no thrill seeking. A slight turn at any of the last several seconds would have avoided the marker. He was asked, question, as the vessel, talking now about Lieutenant Thompson, recreation of the Robalo. As the vessel was traveling in the path at that speed in these conditions, did it appear to be operating unsafely? Answer, no. The only thing that would create a problem is hitting the marker. Answer, correct. This is, as I tried to explain earlier, this is the car that's not driving on I-95 like a lunatic, but gets into an accident because, for example, the car forgot to hit its blinker, took a pass, changed lanes, gets hit, and people get hurt. Did they violate a rule of the road? Yeah, they didn't turn on their blinker. Did somebody get really badly hurt or worse? Yeah, but no one's going to jail for that. And now we come to the 6'8" Lieutenant Albert. And I think he gave you the answer he thought was the cause of this accident. His opinion. He, the police, testified that the passengers seated in the bow area could have obscured the operator's view. Meaning that George Pino was driving along with a swivel, looking, and that the girl sitting in the front obscured his view or perhaps distracted him, and he didn't take note of what would otherwise be a visible marker, and he struck the marker. And you may recall I counted down with him, 9, 8, 7, 6, 5, 4. During any of those 5 seconds, if George Pino had taken note of the marker, he could have avoided by a quick turn of the wheel, not even that quick, just a turn. But if he didn't notice it until 3, 2, 1, it would be too late. And if it's because the seating arrangement made his view of the marker less than ideal, it wasn't because George Pino was trying to be in reckless disregard for people's safety, gross, flagrant, or anything of the sort. A few additional witnesses, the civil attorneys who testified, prosecutor, emphasizes that the insurance company's appointed lawyer for the Pinos, Mr. Mescalado, following insurance company protocol, files a petition for limitation of liability to consolidate all the cases into federal court. A lawyer doing his job, with a client urging him, I want to make sure everybody gets compensated. And the insurance company's lawyer saying, this is how we do business with the insurance company, and George Pino deferring to his lawyer. And still, everything gets resolved civilly. He holds himself accountable. He resolves the issue of compensating people that are terribly injured and worse for their injuries and their pain and their suffering. And yes, George Pino maintained the same memory of the event a year later that he had the day of the event. That's the nature of a confabulated memory. It's the only memory George Pino has of the event. And he shares it with his lawyer. And his lawyer shares it with opposing counsel. And the case gets resolved regardless. Has nothing to do with the decision you have to make about whether George Pino was acting grossly and flagrantly and recklessly. If I could just have a second. early on we talked about the two crimes that George Pino is accused of and which you'll render a verdict on. One of those crimes is manslaughter. And manslaughter, while the elements, they sound alike, manslaughter has two different ways to have the state allege it and prove it. One is, can we put up the manslaughter? Thank you. Thank you. Manslaughter. A, intentionally committed an act that caused the death. I submit to you that intentionally committing an act, the state hasn't proved by any stretch that he intentionally went into that marker which caused the death. It was not George's intent. Then there's the question of culpable negligence that we talked about throughout this presentation. I just want to make sure that we don't miss that there are two different theories that the state is presenting to you. Did George intentionally commit an act that was not merely negligent, that caused the death? Well, the prosecutor told you if he intended to hit the marker, we all agree. Going 47 miles an hour, George Pino intended to crash into the marker, guilty. But that's not what he intended. We all know that. And so the state resorts to this culpable negligence theory. Or maybe the state will say to you his intentional act was turning the steering wheel. And that's the act you should look at. That he intentionally turned the steering wheel, which put him on, as they'll say, a collision course. But you certainly know he did not do that with the intent of crashing into the marker. Or they'll say to you it's culpably negligent, that he should have known. But as we've addressed with you already, it can't be the product of mere negligence. If that's what happened, if George Pino was negligent, he is not guilty of manslaughter. Because turning the wheel, unless you hit the marker, nothing bad happens to anyone. The speed is safe. It's steady driving. The conditions are excellent. We all know what caused the tragedy here is striking the marker. And speaking of the marker, can we show the jury Exhibit J? J and K. You may recall some discussion about the GPS and how George's SIMRAD device, the GPS device, when magnified, the red line purporting to be the path of George's boat, and when it's magnified, for whatever reason, I think Lieutenant Albert tried to explain that the markers are on a different map than the track. It actually shows that George's boat never actually alighted with the marker when you magnify it. Now again, I am not telling you that George Pino was driving, staring at his GPS, and thought that he was going to avoid the marker. But what you know from the track is that as George was going in the channel, which is basically southwest, at some point in time, he starts turning to the left, port, because he's headed to Angelfish Creek. And we know that marker 15 is to his left, to his port side, until he actually strikes it, and he strikes it with his starboard side. So he actually shifts left. Now, he could leave the channel at any time. There's no rule that he has to stay in the channel. There are no other boats in the channel. He can, typically you stay to the right, but if there's no other boats, you can take the middle of the channel. If you want to go in the shallow water, you can just make a right turn or a left turn and go to the shallow water. But I think what this tells you is that George Pino, it did not register that he had one more green marker to go. Because he's doing the veer to the left that he would have ordinarily done when he gets to marker 15. And it may just be, for the reasons we've discussed before, that the state thinks he was inattentive. He should have known he had one more marker to clear before he was out of the channel. Whatever it is, it was not an intentional act to hit the marker. He did not intend to come close to the marker. He intended to take these girls back to Ocean Reef. And so now I'm going to ask you to try to get into George Pino's mind. Because ultimately, our criminal laws are here to punish people who act with a level of depravity, of gross and flagrant behavior, that there's some malice. And when I say malice, I don't mean like malice.
Judge, Your Honor, that's not a state, proper state of the law.
I'll just call it
I'm sorry, counsel. The court will instruct you on the law, ladies and gentlemen. Go ahead, counsel.
some level of, I think maybe the better word is depravity. It's a degree of recklessness that leads you as jurors to believe that George Pino was acting consciously, intentionally against the interests of the passengers on board. And you know that when you see it. The pickup truck that puts people in the back of the pickup in a place where no one is supposed to be seated. I suppose you could use the example of putting a bunch of kids on the hood of a car in front of the windshield, and a car was not made to have people travel on the hood or in the back of the pickup truck. And if you saw someone doing 47 miles an hour with a bunch of young kids in a pickup truck on the interstate, you'd say, whoa, that guy's out of his mind. You'd know it when you see it. But when George Pino left the sandbar that day, it's for you to decide, was he taking extraordinary risk in traveling back to Ocean Reef, back to where he came from? Because failing to exercise ordinary care, if he made a mistake as the operator, that doesn't result in a criminal conviction. There may be civil liability, but not a criminal conviction. And so, what was in George Pino's mind? What was in his heart? And I think it's clear because you know what the occasion was. He was there that day to celebrate a wonderful time, a beautiful time in his life, surrounded by the people he loved. Was he really trying to be a show-off, to be the cool dad, really? By driving his boat back to Ocean Reef while the girls, they probably didn't even notice George Pino. As they told you, they're in their own world. It's not like he had a bunch of race car drivers who wanted to see just how fast a boat could go through an obstacle course. This was a dad with his wife by his side, his daughter seated in the bow area. Perhaps daydreaming, perhaps appreciating a beautiful moment in his life, perhaps thinking about how lucky he is. Does he really think that in his heart and in his mind he was saying, F it. I'll just floor it, and I'll throw caution to the wind. Does anyone really believe that? George Pino? And of course, a bad thing happened. A tragedy happened. And a lot of pain has come from this. And I know that there are a lot of people watching, people that have been affected by this.
Such objection, that's not relevant.
You heard the testimony of people who came to this court and told you the families that were affected by this. And they're watching. And they deserve sympathy. They deserve an open heart from all of us. Their lives have been changed forever. And it's a hard thing to do, to be a juror in a case where those kinds of feelings have been part of this trial every single day. At the same time, the reason why we have jury trials is because we count on people who have no connection to the injuries, no connection to the feelings, who can try to apply the law dispassionately, even if you have sympathy. It's okay, the two things can coexist. We can all be sympathetic. We can all feel the pain that this event has caused so many people. You can feel it. We all felt it when we had to look at some of these photographs, watch some of these videos, and how they've been played over and over again. None of which has anything to do with the cause of the crash, only the injuries that followed from the crash. And the prosecutor has spent an enormous amount of time showing you just how painful this crash was. It doesn't answer the question of what was in George Pino's mind and in his heart, which bleeds for the families that have been affected by him operating that boat. No matter what your verdict is, he will have to live with that for the rest of his life. People he grew to love, people that walked in his wedding, children who spent time in his home. And so in rendering your verdict, yes, we can all be sympathetic, we can all feel the pain. The law says, though, that when you analyze the evidence, you need to do it dispassionately. And I submit to you, if you do it dispassionately, you'll know that there was only love and kindness in that man's heart. And that never once in his mind did it occur to him.
Such objection, the counsel testifying.
There is no evidence, none, that ever once in his mind he thought that he was putting anybody's life in jeopardy. Not his own, not his wife's, not his daughter's, not Lucy's, not Kathy's, not any of the other girls on that boat. And if anybody at that sandbar had thought that George Pino was going to put the lives of those girls in danger, they would have said something, but they knew who George Pino was and is. He may not be the coolest actor, but he's also not a crook. You should find him not to.
All right, thank you, counsel. Ladies and gentlemen, we're going to take a little stretch break. Please put your notebooks inside your envelopes. You can leave them on your chair.